Good evening, sir, and my fellow friends. We are Group 19, and today we'll be advising teenagers regarding the offences found in Sexual Offences Against Children Act, also known as SOACA 2017. My name is Tan Hu Him, and these are my group members. Without further ado, let's get started. SOACA is known as a crucial act for Malaysian law because it was created as a special boundary to protect children from offences such as sexual exploitation and sexual grooming. According to Section 2(1) of said act, child is also being defined as a person who is under the age of 18. When citizens turn 18, they're automatically formulated some adults' rights, such as legal right to vote, civil marriage and medical decision, and many more. This signifies the trust in Malaysia legislation for citizens of 18 years old to be able to make informed and voluntary decisions and be fully responsible for their action. The rationales behind this presentation is to increase teenagers' awareness of this law, especially when they are a vulnerable party like themselves. They're not capable enough to recognize intention, make informed decisions, and understand the consequences of being part of this sexual activity. To briefly introduce, the different types of offences include online or sexual offences, which are sexual communication with children, sexual grooming, child porn, and etc. And physical offences include touching, rape, and more. The punishments are usually imprisonment, fine, and whipping. Then I'd like to give a brief overview of SOACA 2017. Before 2017, Malaysia lacked a specific legislation that protects children, but did not also fully address online and offline grooming. This had led to an infamous case of Richard Huckle 2006 to 2014. This case involved a British man who was found guilty of grooming and sexually exploiting nearly 200 Malaysian children, ranging from 6 months to 12 years old. He was found guilty on 91 charges. After this incident, the government took action to further amend, scrutinize, and further refine the law, such as Child Act 2001. This ensures that the law covers and provides a more effective implementation towards children. In another case that is recorded in News Straits Time, a man was sentenced to 263 years in jail after being found guilty of committing a sexual crime against his 16-year-old stepdaughter. This was reported in May 2003, and the sentences include Section 14A of SOACA 2017. In comparison to the Penal Code, SOACA provides a more comprehensive and inclusive range of protection catered specially to children. The Penal Code covers a more traditional physical sexual offences, where SOACA covers online offences too. The right range of protections include producing, distributing, and etc., making it applicable for children witness and collaborative rule. This covers the most of the gaps that is found in Penal Code. In conclusion, SOACA aims to provide a greater protection, especially with the rise of social media dependency and usage. Children and teenagers are usually afraid to speak up because, as reported in UNICEF, they are usually under a impression of incomplete understanding, fear of punishment, desire to protect, and many more. Thus, this presentation aims to provide a more well-rounded overview of the different types of offences that the teenagers might need to take aware of and that is found in SOACA 2017. And we are hoping to advise teenagers regarding it. That is it for my part. Next, I would like to pass it on to the next presenter. Thank you.
In this part of presentation, I'll be discussing the different category of sexual offences with a particular focus on online sexual offences involving social media platform, messaging applications, and online gaming environments. These offences have become increasingly significant in today's digital era as children and teenagers are highly active online. While these platforms provide opportunities for communications, learning, and entertainment, they also create spaces where offenders may exploit and target minors. In response to the risk, Part 3 on child grooming under the Sexual Offences Against Children Act 2017, SOACA 2017, criminalized various forms of online sexual conduct involving children. Firstly, sexual communication with children refers to any form of communication conducted through digital platform with an adult sends, requests, or engage in sexualized messages with a person below the age of consent. Even where no physical contact occurs, under Malaysian law, this conduct is clearly criminalized under SOAICA 2017, particularly Section 11, which make it an offense to communicate sexually with a child through words, images, or electronic communications intended to obtain sexual gratifications or prepare the child for sexual activity. In this regard, O'Connell 2003 explained that online offenders often rely on gradual trust-building techniques, beginning with seemingly harmless conversations before progressing into sexualized interactions. Secondly, the sending inappropriate messages or images to children is also covered under Section 11 and 15 of SOAICA 2017, depending on the nature of material involved. This includes sending explicit images, pornographic content, or sexually suggestive messages intended to arouse or exploit a child. Such conduct is commonly facilitated in online environments due to the anonymity they provide. For instance, offenders may send unsolicited explicit material or pressure children into sending sexual images in return, which may also constitute child sexual exploitation material offenses under Malaysian law. Davidson 2011 note that online offenders frequently use sexual imagery and text to desensitize children and intensify sexual engagement over time gradually. This forms part of a broader grooming process where communication is used to normalize sexual behavior and weaken the children's ability to resist or seek help. Thirdly, sexual grooming refers to the process whereby an adult builds trust and emotional connections with a child through online platforms for sexual exploitations. This is specifically addressed under Section 12 of SOAICA 2017. In practice, grooming usually occurs gradually, starting with friendly or casual conversations, sometimes where the offender pretends to be a peer before slowly introducing sexual content or intentions. Whittle 2017 explained that grooming is a structured process involving trust building, manipulations, and psychological control over the victim. For example, an offender may engage a child through sexual media or online gaming platform, gradually gaining trust before attempting sexual exploitations. Lastly, Section 13 of SOAICA 2017 further criminalized meeting or attempting to meet a child after prior sexual communications or grooming, where there is an intention to commit a sexual offenses. This offense is preventive in nature, targeting situations where online interactions progress towards arranged physical meeting for sexual purpose. It also includes cases where offenders impersonate teenagers online to build trust before arranging in-person meeting with minors. Coyle and Taylor 2017 explained that online to offline offending typically follows a predictable pattern, beginning a relationship building, moving into sexual communications, and ultimately leading to attempt at physical contact. This progression shows how online grooming can translate into real-world harm if not stopped early. Now we are going to discuss the legal consequences of online offenses and punishments. For sexual communications, in terms of legal consequences, liability under Section 11 arises once it is proven that the accused intentionally engaged in sexual communication with a person under the age of consent. The prosecution does not need to prove the physical sexual activity occurred. It is sufficient that the communications was sexual in nature and directed at a child. This reflects the preventive purpose of the provisions, which is to stop exploitations at an early stage before it escalates into grooming or physical abuse. The punishment for Section 11 provides for a custodial sentence of imprisonment, which may extend up to 5 years, a fine, or both. Sending inappropriate messages or images may also give rise to liability under Section 292 of Penal Code, which criminalizes the transmission of obscene material to minors. The law treats this as an act that corrupts and exploits a child's sexual innocence, even without any physical interactions. Upon convictions, the offender may face imprisonment of up to 3 years, a fine, or both. Courts often impose custodial sentences in cases involving deliberate targeting of minors, as psychological and developmental harm is considered particularly serious. In addition, sexual grooming liability may extend to Section 377E of the Penal Code, which criminalizes the inducement or encouragement of gross indecency involving a child, even where no physical sexual act is completed. This reflects the law's preventive approach, targeting early-stage exploitations before it escalates. Upon conviction, the offence carry imprisonment of between 3 and 15 years, highlighting the seriousness with which Malaysian law treats grooming and preparatory sexual conduct involving minors. In terms of legal consequences for meeting or attempting to meet a child after prior sexual communications or grooming, liability arises once it is proven that there was a prior grooming of sexual communications, combined with travel or arrangement to meet the child, and the intention to commit a sexual offence. Upon convictions, the offender is liable to imprisonment for a term not exceeding 10 years and may also be subjected to whipping, reflecting the seriousness with which Malaysian law treats preparatory acts leading to child sexual exploitations.
Hi, my name is Aisha and I will be discussing child pornography offences under Malaysian law, the key legal provisions involved, and why these offences are considered extremely serious. Under Sexual Offences Against Children Act 2017 or SOACA 2017, child pornography refers to any visual, audio, written, or digital material that depicts a child engaged in sexual explicit conduct. Importantly, this definition is very broad and includes not only real images or videos, but also edited, manipulated, or digitally generated content. Now, the Act creates several offences relating to child sexual abuse material. Section 6 criminalizes the creation or production of such material, while Section 7 makes it an offence to use a child in the production process. Section 8 prohibits distributing, sharing, transmitting, or publishing child pornography, whether through physical means or online platforms such as WhatsApp, Telegram, Instagram, and also TikTok. Section 9 and 10 further criminalizes the sale, supply, possession, storage, or access of child sexual abuse material. This means that a person does not need to create the content to commit an offense. Simply possessing, saving, or knowingly accessing such material may also result in criminal liability. The Act also recognizes the dangers of online grooming. Sections 11 to 14 criminalizes sexual communication with children and grooming-related behavior, allowing authorities to intervene before physical abuse actually occurs. These provisions work together with other Malaysian laws also. Section 292 of the Penal Code criminalizes obscene materials, while Section 233 of the Communication and Multimedia Act 1998 makes it an offence to use the network facilities to transmit obscene or offensive content electronically. Malaysian courts have consistently taken a strict approach towards online sexual offences. In Public Prosecutor versus Nur Fitri's Azmir Nordin, the court demonstrated the seriousness of offences involving indecent digital content and the misuse of online platforms. This reflects the court's commitment to protecting children and deterring cyber-related sexual offences. Now, why are these offences considered so dangerous? First, they cause severe and long-lasting harm to victims. Children who are exploited in such material often suffer emotional and trauma, anxiety, depression, and psychological distress that can continue for many years. Second, the internet makes the harm even worse. Once content is uploaded online, it can spread rapidly and remain accessible indefinitely, even if the original post is deleted. Copies may continue to circulate, causing repeated harm to the victims. Third, the circulation of child sexual abuse material creates demand for more content, which encourages further grooming, exploitation, and abuse of children. Finally, many teenagers mistakenly think that forwarding inappropriate content as a joke is harmless. However, sharing, storing, or possessing such material can lead to serious criminal consequences. What may seem like a simple click or forward can have lifelong consequences for both the victim and also the offender. In conclusion, SOACA 2017 provides a comprehensive legal framework that criminalizes the creation, distribution, possession, and online communication related to child sexual abuse material. These laws exist because the harm caused to a victim is severe, lasting, and often irreversible. As teenagers, it is important to be responsible online, think carefully before sharing any content, and remember that digital actions can have real legal consequences. Thank you.
My name is Julie Asher Jeffrey, and I'm going to be presenting on physical sexual offenses against minors. To start off, under Malaysian law, a child is defined as a person under the age of 18, where physical sexual offenses against children are mainly governed by the Penal Code and the Sexual Offences Against Children Act, also known as SOACA 2017. Under the Penal Code, Section 375, subsection G, criminalizes statutory rape, where a man commits rape if he has sexual intercourse with a girl under 16 years old, regardless of consent. And this reflects the law's position that minors cannot legally consent to such acts. Moving forward, we have another important provision, which is Section 377 capital E, which criminalizes inciting a child under 14 to commit acts of gross indecency, even if sexual intercourse does not occur. In order to strengthen child protection, Malaysia then introduced SOACA 2017, which specifically addresses the offenses like child grooming, child pornography, abuse of trust, and also sexual assault against children. As an example, we will be using Section 14 of SOACA, which criminalizes physical sexual assault, where a person commits an offense if, for sexual purposes, they touch a child, make the child touch another person, or touch themselves. Conviction may result in imprisonment of up to 20 years and whipping. Here we have a case of public prosecutor and Ahmad Firdaus Yusof in 2023, where the court held that the prosecution must prove the touching was done for a sexual purpose, not merely physical contact alone. Furthermore, Malaysian law also criminalizes penetrative offenses such as penetration by object, anal or oral penetration, and incest under these sections, in which Section 377 capital C capital A, Section 377 capital C, and Section 376 capital A of the Penal Code. To add on, Section 16 of SOACA imposes stricter punishment on persons in position of trust, such as parents, teachers, or religious instructors who commit offenses against children. Last but not least, Malaysian law currently does not recognize the sweetheart defense for consensual sexual acts between minors, as the law prioritizes the protection and welfare of children. That's all from me. I will be passing on to the next part to my other teammates. Thank you.
I'm Nicole. After the earlier members have explained the offences under SOACA 2017, my part focuses on rights, reporting, and protection on what teenagers should do if they or someone they know is affected, where they can seek help, and what protection follows after reporting. First, a teenager affected by a sexual offence should be treated with safety, privacy, dignity, and support, especially when disclosure may be delayed by fear, self-blame, threats, or stigma. When a teenager speaks up, the correct response is to listen calmly and help them reach support. If a teenager becomes a victim, the first safe step is to tell a trusted person such as parent, guardian, teacher, or school counselor. The teenager should not confront the suspected offender or investigate the matters alone. If a friend discloses an incident, we should listen calmly, take it seriously, avoid blaming or spreading their story. Instead, we should help them reach a safe adult, legal authorities, or professionals to handle the investigation and protection. This is illustrated in Ghazali bin Abdul Majid against Pendawar Raya, where the victim's friend informed a teacher and the teacher assists the victim in obtaining hospital care. Safe reporting may involve the police, JKM, Talian Kasih 15999, and hospital services. A police report allows investigation to begin, while welfare authorities may assess whether the child needs further protection. Talian Kasih is an official 24-hour help channel operated by JKM under KPWKM. Hospital may also provide medical and crisis support such as all SCCs in Malaysian government hospitals and SCAN teams as part of the response to sexual assault and child abuse. Next, evidence matters because legal action must be based on reliable information. Useful evidence may include the victim's account, medical evidence, witness information, and key details such as who, where, when, and who was first told. However, the burden of building the case should not be placed on the child. This is illustrated in Sanusi bin Makato against Pendawar Raya. In this case, the victims informed her mother, who promptly brought her to lodge a police report. The High Court considered the victim's account together with medical and supporting evidence. Importantly, the court did not reject her evidence merely because of minor memory inconsistency. A victim should not be blamed for delayed disclosure or imperfect memory. Teenagers should preserve useful information such as relevant details, but they should not forward or repost sensitive materials and should not circulate anything that may expose the victim's identity. Protection must continue after reporting. Under Section 2 of the Child Act 2001, a child is a person under 18 years old. Under Section 17, subsection 1, a child may need care and protection where they have been sexually abused, are at substantial risk, or where a parent or guardian fails or unlikely to protect them. The Child Act 2001 provides a structured protective response. Section 7 provides for child protection teams. Section 18 and 19 allow temporary custody and court for children oversight. Section 20 to 22 covers medical examination, treatment, and hospitalization. Section 24 includes psychiatric treatment, while Section 25 requires court involvement after treatment or hospital discharge. These provisions show that reporting may lead to safety measures, medical care, emotional support, and judicial supervision. Privacy is also central. Under Section 15 of the Child Act 2001, identifying details and picture of a child victim or witness must not be exposed through media reporting or electronic transmission. Under Section 14 of the Evidence of Child Witnesses Act 2007, a child witness's identity is similarly protected. Protection must also include emotional recovery because victims may continue to struggle with trust, vulnerability, and emotional distress. This is supported by Public Prosecutor against Moha Ramzan bin Ramli, which highlights the betrayal of a relationship of trust and the need for continuing professional support. Finally, the child's voice should be heard through a process that reduces further distress. The Act 676 applies to a child witnesses under 16 years old. Under Section 3, the child may give evidence through a screen live link or video recording. Section 8 and 9 allows an intermediary and accompanying adult. These measures help the child be heard while reducing avoidable fear and distress. In conclusion, teenagers should know that they can speak to a trusted adult, seek formal help, preserve useful information responsibly, and expect continuing protection after reporting. Thank you.
As mentioned previously, the Sexual Offences Against Children Act 2017, also known as SOACA 2017, not only represents Malaysia's child protection framework, but also serves as advice to teenagers about the principal offences under this act. The act is a protective measure, and its broad application means that teenagers must understand its reach, as both potential victims or offenders perhaps. Teenagers should not assume that their age provides immunity. The SOACA 2017 does not exempt individuals under the age of 18 from its provisions, as Section 2 Sub 1 specifically defines child as a person under the age of 18, which includes teenagers, and this applies to the victim. Thus, even a teenager can be charged under this conduct if they commit the offense, even if the conduct was consensual or exploratory, so long as the victim was a child. Consider a recent case in Malaysia where a 15-year-old was arrested for sexually assaulting a classmate. It was reported that the suspect allegedly committed the act during recess and was arrested the same day. The charge in this case was filed under Section 14 Sub A of SOACA 2017, as it defines the offense of physical sexual assault on a child. Furthermore, the court may also impose a custodial sentence for a specific period of time, subject to Section 96 Sub 2 of the Child Act 2001, as it highlights where before a minor can be sentenced to imprisonment, the court must first consider all other alternatives available. Going back to Section 14 of the SOACA 2017, where it criminalizes physical sexual assault, including any touching of a child's body part with sexual intentions, this provision does not specify any exceptions for consensual conduct between minors. As a result, a 16-year-old boy pleaded guilty under this section for sexually touching a 15-year-old girl, and said girl also pleaded guilty under Section 5 for a digital production she sent to the boy in a 2020 case in Cebu. This case shows that sexting, an activity commonly seen between teenagers or younger relationships, is also an offense that can be committed,
regardless or not whether there was any sort of consent. So while the Act was primarily designed to target predators, it can also apply to anyone above the ages of 10 years old, who also engages in any sexual activity with another person under the age of 18. However, this approach has been criticized by the Child Rights Innovation and Betterment Foundation, known as CRIB, which described this sort of prosecution as a misuse of the Act, arguing that the law should not be used against children in consensual relationships. Section 19 of the Act imposes a mandatory duty on any person who has reasonable grounds to believe that an offense under the Act has been committed to report it to the police. This duty applies to all persons, including teenagers, without exceptions. The rationale for including minors as duty bearers is to ensure that no legal ambiguity prevents a young person who witnesses or experiences an offense from coming forward. The special guidelines on handling child sexual abuse cases emphasizes that police reports must be made urgently, particularly for cases occurring within 72 hours. Basically, the Act removes any legal barrier to self-reporting, as the police have a duty to accept such reports and to handle them sensitively. The government has also introduced child-friendly court procedures and victim support mechanisms to minimize the trauma. While the Act provides for severe penalties, the courts have also shown some leniency for child offenders. In the case of a 15-year-old charged under Section 14A mentioned earlier, the court actually considered a community service order or placement in an approved school such as Henry Gurney School as potential sentences. As the accused pleaded not guilty back then, he was also granted bail of Rm 2,000 with one surety. If it were anyone else committing this case, the maximum sentence the offender may face can go up to 20 years and is liable for whipping. This is a big comparison to what the accused in this case faced originally. Similarly, a 19-year-old was ordered to be sent to Henry Gurney School under age 21 for possession of child sexual abuse material. The actual punishment for accessing or possessing child sexual abuse material, as stated in Section 10 of the SOACA, can go up to 5 years in prison or a fine of around Rm 10,000 or both. So it's safe to say that while the court shows some leniency towards teenagers and younger offenders, they also have the discretion to impose punishments as serious as imprisonment and whipping if they see fit. Even if a non-custodial sentence is imposed, a conviction of any kind can affect one's future education, employment, and travel, which ultimately will affect the individual's life forever. In conclusion, the Sexual Offences Against Children Act 2017 is a powerful tool for protecting children, but its broad scope means that teenagers must be aware of its application to their own conduct. The best advice for anyone and everyone is to refrain from any sexual activity or communication with another minor until both are over the ages of 18, and this cautious approach accounts for the Act's strict liability provisions, the difficulty of proving mutual consent among minors, and the potential legal consequences of a report to the police. Ultimately, awareness and prevention remain the most effective complements to the Act's protective mechanisms.